Hey everyone, let's talk about digital law and e-commerce. In this lesson, we'll describe the internet. We'll explain how email contracts and text contracts are formed. We'll describe electronic commerce and contracts. We'll describe electronic licensing of software and informational rights. We'll describe laws that protect privacy in cyberspace. We'll define domain name and describe how domain names are registered and protected. So let's dive right in. Just to get started here, electronic commerce or e-commerce is just the sale of goods and services by computer over the internet. Everybody is well aware of what this is and pretty familiar with it at this point. The federal government has enacted many federal statutes that regulate the internet and e-commerce. There are also some state laws thrown in there. There was a need when e-commerce was getting off the ground to deal with the legitimacy of electronic contracts and signatures, the security and privacy of electronic systems, and intellectual property rights and protections. We had never dealt with the internet before. It was a brand new thing. We had to try to figure a lot of stuff out. So the internet is a collection of millions of computers that are all networked together to produce the World Wide Web. I think everybody knows what this is. The websites and pages are stored on servers operated by internet service providers. And as we all know, it's extremely attractive for businesses to conduct business online. An email contract is a contract you form via email, but you really don't even have to be that specific. It's just an electronic contract, really. And even then, it's just a contract now. We've hammered out enough about contracts and e-contracts to just consider them as being normal contracts. We figured out that the e-contracts meet the requirements of the statute of frauds as far as being a writing. So the CAN-SPAM Act, Controlling the Assault of Non-Solicited Pornography and Marketing Act, is a federal statute that places certain restrictions on persons and businesses that send unsolicited commercial advertising that we call spam to email accounts. The idea here was to try to cut down on the amount of spam that we're all getting in our email inboxes. So it prohibits spammers from using falsified headers and email messages. It prohibits deceptive subject lines that mislead a recipient about the contents or subject matter of the message. It requires that recipients of spam be given the opportunity to opt out. It's why in our emails we see that unsubscribe link. The thing is, it's mostly useful against legitimate companies who are actually going to follow the rules. As we all know, spam is always going to be with us. A lot of it comes from bad actors that are operating overseas or just are concealing their identities in some other way, which makes it difficult to enforce if we can't track down who they are. But for the legitimate companies who are following the rules, they have to be truthful in their headers, and the unsubscribe link actually is supposed to work so that you can unsubscribe from their email list. An internet service provider is a company that provides consumers and businesses with access to the internet. So some of the common big ones are Spectrum and AT&T, Verizon. There's also very large companies like Microsoft and Amazon who do a lot of hosting of websites. The Communication Decency Act, in the early days of the internet, there were a lot of questions surrounding if people are transmitting illegal content over computer networks. Are the ISPs liable for the stuff that's going on? And a lot of these questions came about as a result of, early forms of piracy of copyrighted works like Napster, where you're trying to figure out whether or not you're going to hold AT&T liable for, transmitting a stolen work, through Napster or something like that. But the Communication Decency Act says that ISPs are not liable for content transmitted over their networks by email users and websites. So if we're looking for who's liable, it should be the email user or the website rather than the ISP. Bringing that into the modern age, if a company feels like their copyrighted work is being transmitted illegally, they can notify the ISP, and the ISP might have a responsibility to try to take that content down if they can, but they probably aren't going to be liable. So a web contract is just a contract entered into by purchasing, leasing, or licensing goods, services, software, or other intellectual property from websites operated by sellers, lessors, and licensors. We're assuming all the elements of a contract are present. E-contracts are valid and enforceable. So we have a case here, Hubbard versus Dell Corporation. In this case, the plaintiffs purchased computers online through Dell's website. To purchase, the plaintiffs completed online order forms on 5 pages of the website. On each page, Dell's terms and conditions were accessible via clicking a blue hyperlink called Terms and Conditions. The last page of the order form stated the sales are subject to Dell's terms and conditions of sale. The terms and conditions contained an arbitration clause. The plaintiffs sued Dell, claiming misrepresentation of microprocessor speed. Dell moves in court to compel arbitration as provided in their terms and conditions. The plaintiffs claim that the arbitration clause is unenforceable because the terms were not adequately communicated to the plaintiffs. They basically didn't click on the terms and services to read them, so they didn't know there was an arbitration clause there, and now they're saying it's unfair and it shouldn't be enforced against them because they didn't read the terms. So this is one of these early testings and this happened back in 2005, so we're trying to figure out, can you just have a link there to your terms of service and then hold everybody responsible for what's contained in those? And this was a big testing of that. So the issue here were the terms and conditions of sale adequately communicated to the plaintiffs. The court said the blue hyperlinks should be treated like turning a page of a multi-page contract, revealing more pages. The links were conspicuous enough, even though there's not a requirement for how conspicuous it has to be. It's not like the link was hidden. It was on every one of the pages in a blue hyperlink. They could have easily clicked on it to read the terms. Since the terms were part of the online contract, the plaintiffs are bound to them even if they didn't read them, which includes the arbitration clause. So the lesson here is that you can be held responsible for terms and conditions of sale on the internet when you order something, even if you don't read them, which a lot of people don't do. I would say the majority of people don't read them. So if you ever want to it is interesting reading if you order something off the internet. Click on those terms and services and sort of read down, see what you're actually agreeing to. The e-Sign Act is the Electronic Signatures in Global and National Commerce Act. It's a federal statute that recognizes electronic contracts as meeting the writing requirement of the statute of frauds. In other words, electronic contracts are just as valid and enforceable as contracts written on paper. It recognizes and gives electronic signatures the same force and effect as pen-inscribed signatures on paper. Electronic signatures can take multiple different forms. It might be typing my initials into a box. It might be as simple as just checking a box saying that I agree to these terms and services, but it gives that electronic signature the same force as handwriting their signature on a piece of paper. There are some consumer protections built into the e-Sign Act. The consumers must consent to receiving electronic records and contracts. Consumers must be able to demonstrate that they have access to the electronic records, and businesses must tell consumers that they have the right to receive hard copy documents of their transaction. You've probably gone through all of these steps before when dealing with something even as simple as like your utilities company when you sign up for paperless billing, and you have to agree to going paperless. You have the right to get the paper bills if you want to, and it's all just part of the e-Sign Act. Counter offers are ineffectual against an electronic agent. Most internet sellers have systems that use electronic agents, basically automated systems that handle sales and inventory and stuff like that. So we define electronic agent as being a computer system that has been established by a seller to accept orders. What does this mean? It just means that if I go on Amazon and order something, I can't then send a follow-up email to Amazon corporate containing a bunch of additional terms that I would try to hold them to. That kind of counteroffer would not be upheld by the court. So we'll talk about licensing a little bit. So obviously on the internet it becomes very, very easy with digital intellectual property. It becomes very, very easy to copy and make multiple copies of stuff and then transmit that around the internet. So people who invent software are going to try to figure out how to protect their intellectual property. So there was an attempt to create a uniform set of laws for all states in the form of UCITA, which is the Uniform Computer Information Transactions Act. It was a model state law that creates contract law for the licensing of information technology rights. Their intention was to try to get all the states to adopt it. It governs the creation, performance, and enforcement of computer information transactions. It really only has been passed by 2 states, Virginia and Maryland. A lot of other states, I'd say most other states, have passed anti-UCITA laws preventing it from being enforced in that state. That includes North Carolina, which we passed in 2001. The critics of UCITA said that it was too friendly to the companies, allowing them to escape liability for problems with their software. So in North Carolina, we have something called the UETA, which governs contracts in our state. An electronic license is a contract whereby the owners of software or a digital application grants limited rights to the owner of a computer or digital device to use the software or digital application for a limited period and under specified conditions. A licensing agreement is a detailed and comprehensive written agreement between a licensor and a licensee that sets forth the express terms of their agreement. Now, we all deal with electronic licenses all the time. If you rent a movie, if you buy a song, you don't actually own the movie, you don't own the song. What you have is a license to watch that movie or listen to that song for some period of time. Maybe it's forever, maybe it's for only as long as my subscription is valid, and I can't go make money off of that. I can't just open up a restaurant and play all those songs without paying out the intellectual property owner. I can't buy a movie online and then open up a theater and then charge people to come watch that movie. I have a very specific license that usually just covers home use only. If I'm going to do something like open up a theater or charge people cover to come to my bar and play it to the general public, I'm going to have to have a different kind of license that's going to cost me more money. An exclusive license is when a licensee grants the licensee exclusive rights to use some information for some specified duration. So if I'm getting exclusive information that nobody else can use, that would be an exclusive license. A little bit of terminology regarding licenses is the licensor is the owner of the intellectual property or information rights who transfers rights in the property to the licensee. The licensee is then the party who is granted those rights to that intellectual property or informational rights owned by the licensor. The licensee doesn't get ownership of the IP or the informational rights. They just get some restricted ability to use it. The licensor always has ownership over that IP. The Electronic Communications Privacy Act makes it a crime to intercept electronic communication at any point, whether it be during creation, transmission, receipt, or storage. If I am wrongfully accessing somebody else's computer or connection and taking information that's not mine, that would be a violation of the Electronic Communications Privacy Act. There are 2 important exceptions to that. One is when the party or entity providing the electronic communication service, so basically the person who owns the communication service. So the biggest example there being an employer who is accessing company email records of an employee. If I'm an employee of a company, I'm using company email. I really don't have a whole lot of privacy rights there. The email system is owned by the company. It's theirs. They can find out what I'm emailing, and that's perfectly okay, at least in almost every situation. The other exception would be for government and law enforcement entities that are investigating suspected illegal activity. Obviously, the FBI or the police or the CIA or whoever who is investigating suspected illegal activity on the internet can gain access to their systems. You may or may not be aware that they're gaining access. You probably aren't, because they want to keep that kind of thing a secret. So I put in here, there's a thing known as a canary clause where a company like Facebook or a company like Reddit or somebody like that who deals with a whole lot of electronic communication, they would put a clause in their terms of service or in their privacy policy somewhere saying that no governmental organization has requested the records of any of our users, and they kept that policy or that clause in that those terms. And if you saw that clause in those terms, that the government has not come in and tried to get the records of an individual using those services. However, if the government did approach Facebook or Reddit or Twitter or whomever requesting the user information of one of their users, the government would oftentimes forbid Facebook or Twitter or Reddit from telling people that the government had requested this information. So rather than telling their users, what they would do is just remove that clause from the terms. So if you're looking back over the terms and you don't see that clause anymore, that means, well, it's at least a very good indication that the government has actually made a request for some of that information, and they probably were compelled to provide it. Although we do see some companies like Apple who take a strong stance with like their encrypted text messaging or WhatsApp or something like that, where the government tries to get a backdoor to be able to get messages of private citizens, and that company's so far refused. We'll see how long that lasts. The government is trying to figure out how to gain access to those systems, and you can sort of see a trade-off there. If there are bad guys out there who are conducting business that's encrypted and we don't know about it, we could maybe prevent or stop some crime if the government was able to access it. However, it would come at a pretty big cost for privacy, meaning there might not be any way for you to communicate online without the government having the ability to go in and access that. A domain name is a unique name that identifies an individual's or a company's website. When you create a website, you're going to create a name, you're going to make sure nobody else has that name, and you're going to register your domain name so that then nobody else can use that domain name for you. So if your company is johnsbigapples.com, you register johnsbigapples.com and nobody else can use that name. The domain name system, otherwise known as DNS, is the system that takes IP addresses, like the big long one I gave you there in the PowerPoint. It translates those into names that are easy to remember. So that IP address is actually one used by Google.com. So when we go to our browser and try to access a website, we don't type in 192.1.68. A bunch of other numbers. We type in Google or Facebook, and DNS is the system that allows us to do that. ICANN is the Internet Corporation for Assigned Names and Numbers. It's a nonprofit group based in the United States that basically organizes and coordinates domain name registries. It introduces new top-level domains and helps maintain network stability. It's a pretty powerful organization. They basically keep the internet running by organizing how we handle all those domain names. There's a lot of commonly used top-level domain names. .com by far is going to be the largest one. .org is also used by a lot of nonprofit organizations. .us you see sometimes. .gov would be used by governmental organizations. .edu would be used by educational organizations. There's a lot of other top-level domains you don't see used very often, but they do exist, and I guess you can use them. The biggest advantage to using the more common ones is it's going to drive a lot more traffic to your website because it's easier for people to just type in that name. The Anti-Cyber Squatting Consumer Protection Act is a federal statute that permits trademark owners and famous persons to recover domain names that use their names where the domain name has been registered by another person or business in bad faith. There was this big trend in the early days of the internet where people who were a little bit more ahead of the curve would register domain names of big businesses or famous people. So I could register like KimKardashian.com and then just sit on that and then wait until Kim Kardashian was actually trying to create a website for herself, and then hope that she would come to me and offer me a bunch of money for me to turn that domain name over to her. A lot of people view this as being wrong. All reality is it probably is wrong. So that's where this Anti-Cyber Squatting Consumer Protection Act comes into play. If somebody else is using your personal name or your business's trademarked name, or if it's substantially similar enough to where it would cause a bunch of confusion, I might be able to sue and get that domain name turned back over to me. The fundamental requirements are that the name has to be famous. The domain name has to be registered in bad faith. So bad faith would be, sitting on the name trying to make money off of it. Good faith would be, it might be the case where, if I'm a big Guns N' Roses fan and I create GunsN'RosesFanClub.com just because I really like them and I'm actually, posting a lot of content, maybe even doing business on there and actively using the website. Maybe that's not a bad faith use. It's ultimately going to come down to a court to decide. But yeah, there you go. Each country has its own top-level domain. Sometimes they use these. Sometimes they just use .com for ease of use. But a lot of times, if you're looking at a foreign website, you can tell where the website's from just by looking at the .fr for France or the .co.uk for England or something like that. So, a case having to do with cyber squatting is New York Yankees partnership doing business as the New York Yankees baseball club. This was not done in court. It was done in an arbitration forum, but it does illustrate the concept here. The facts of the case were that the New York Yankees baseball club owns the trademark for the New York Yankees. There's a company named Moniker Online Service that registers nyyankees.com and operates a commercial website offering links to third-party ticket sellers and selling Yankees merchandise without the permission of the Yankees. So we're dealing with a couple of things here. If I'm going to be selling the merchandise of a professional team, I'm going to need a license to be able to use their trademark. They probably weren't using the license. They didn't have the permission. So we're dealing with licensing. We're also dealing with cyber squatting. We're dealing with multiple things here. But the Yankees filed a complaint in arbitration alleging that Moniker registered the domain name in bad faith in violation of ICANN's Uniform Domain Dispute Resolution Policy and seeking to obtain that or basically take that domain away from Moniker. Big issue here, did Moniker violate ICANN's Uniform Domain Dispute Resolution Policy? The way that the arbitrator looked at it was that Moniker's domain is confusingly similar to the Yankees mark, confusing enough to a consumer where they might think that the actual New York Yankees are running the website. There was no evidence that Moniker was commonly known by the Yankees or should have any real reason to use the Yankees in their website name. The use by Moniker was indicative of intent to disrupt the business of the Yankees and constitutes bad faith. So they ordered the domain to be transferred back to the Yankees. That's it for this lesson. I'll see you guys next time.